Write short note on consensus and IDEM. So what is consensus and IDEM? Consensus and IDEM is a Latin term that means an agreement of parties to the same thing or a meeting of minds. The essence of an agreement is the meeting of the minds of the parties in full and in final agreement. Before there can be an agreement between the two parties, there must be consensus and IDEM. This means that the parties to the agreement must have agreed about the subject matter of the agreement in the same sense and at the same time. Unless there is consensus at IDEM, there can be no contract. For example, A owns two buildings, red and white. A wants to sell a red building to Mr. B. Mr. B thinks he is purchasing the white building. So there is no consensus ad item and as a result there is no contract. In order to determine whether in any given agreement there is existence of consensus ad item, it is usual to employ the language of offer and acceptance. Thus, if A says to B to buy his red building and B agrees to buy the red building, then there is consensus ad item and agreement comes into existence. In CWT versus Abdul Hossain Muhammad Mullah Muhammad Ali 1988, the Supreme Court cited that in addition to the existence of agreement and presence of consideration, there is also third contractual element in the form of intention of the parties to create legal relationship. So as per section 13 of the Indian Contract Act 1872, two or more persons are said to consent when they agree upon the same thing in same sense. So, intention to create legal relationship is on the same thing in the same sense. So, true consent is consensus allied.